search warrant essentially that was given did not give any.
Excuse me a second.
Sorry,
because I mean, I was following you up until that point, kind of.
Yep.
I don't know what's being attempted to be admitted. So it's a little bit hard for me to place what you're objecting to in context. Is there a way to sort of generally describe what the purported exhibit 1 is?
Information from my phone it's extremely broad, Your Honor. There were no limitations based on what the magistrate had signed off on giving them permission to search. I was hoping that people would be able to get to that and allow the officer to testify to what he was actually able to extract from the phone.
It's like the second person that thinks that we put people in here and make them stay. Yeah, I don't know why people feel they can't leave. It's got to be my magnetic personality. I thought. Did you call?
Yeah.
Were they listening to you?
Yeah.
Okay, all right, calm down. Thought I'd ask. Why are you looking at me? I know you're making me uneasy. Where else? Court does call the case of the People State of Michigan versus Jerome Burns.
Good morning, Your Honor. Mary House, Assistant Prosecuting Attorney on behalf of the people.
And good morning, Your Honor. Assistant Public Defender Chinazi Kariaki on behalf of Mr. Jerome Burns. Can I say your name for the record, please?
Jerome Burns. Thank you. All right. The date and time for continuation of the preliminary examination. Ms. Tanner, you may proceed.
Thank you, Your Honor. People are ready to proceed. A few things for the record, Your Honor. First of all, we have with motion for sequestration of witnesses. We've asked all witnesses to leave. We have our first witness here present in the gallery, as well as the officer in charge sitting at the table next to me.
All right.
I don't see any witnesses on the defense side.
Defense side. All right.
Your Honor, the second thing is, I know we've had an email chain back and forth and some communication between myself and defense counsel, and at one point the court, there was a request from defense to obtain defendant's entire phone, so the whole extraction. Defense counsel and I met, I believe it was Monday, August 4th, with the officer in charge and Detective Cargill, who did the extraction at UMPD, to essentially talk about the evidence, do a review so that we would both be ready here today. We gained a lot of information. We did review some of the evidence. However, that wasn't the full extraction. It was explained to both of us that that would be a giant file, and the detective wasn't sure if our computers would be able to handle the entire file. So at that point, my understanding was that if anybody needed to look at anything that wasn't already provided to us, and counsel can speak to this as well, but Detective Cargill was very good about letting us know his schedule so we could meet with them and go through things. And he also explained that usually in these types of cases, if there is any thoughts, concerns about there being exculpatory evidence on a defendant's phone, that would be the process. Is you would kind of walk in, meet with him, he would pull it up and review it. Again, we did some of that Monday. There has been preliminary data that both sides have. There's been an additional report called Digital Evidence Forensic Report from Detective Cargill, which both sides have and have had for a while, with the information that he gathered based on his training and experience conducting these types of investigations, he felt was associated with this case for us. There was then a request, I believe it was Thursday, August 7th, from defense counsel for the entire file, the entire extraction, and Detective Cargill started working on that. We ended up receiving a thumb drive yesterday at our office, needed to be copied for us to retain a copy and then turned over to defense. That just could not be done in time. It's a large file. Of course, we have these come in all the time and we're scheduled for hearing this morning. There was a brief moment where we weren't sure if we were going to be able to proceed today. There was never an actual adjournment request from either party. We just were kind of trying to figure out if defense needed everything. I had everything they needed to proceed today. So I emailed defense counsel, I've emailed the court. We've all been on that communication. But as of yesterday, my understanding is that we're all ready to proceed.
That is the court's understanding. I really was, well, I won't say I wasn't answering, but as it was going back and forth, I was looking for a request to adjourn and then was going to make a decision if there was one, but actually there wasn't one as I understood it. And I think as you were communicating with Ms. Wildman, at the very end of the emails, we were getting a clarification as to where we're going to go today, and that was it. Ms. Eckenrode, anything you want to say?
Yes, Your Honor, just for a bit of clarification, we did, I think it was August the 4th that we had met with Detective Cargile. But on that date, I think when at least when I went in, I was expecting the ability to view the entire file because I was told that they obviously had a copy of it. But when we went there, Detective Cargile then realized that the thumb drive that was presented to us was not, it didn't contain the entire contents of the phone. He then said that he would work on getting us the thumb drive or transferring the information from that. I wanted to clarify that because by the way it was presented, it seemed as if that request was not made by me until Thursday of last week, but it was in fact made on the date that we had met with.
The original, okay.
Correct. So we, obviously they were not able to get the entire thumb drive with the information from the phone over to us. When the people asked if we were ready to proceed, I think the question that we just had from the beginning has remained the same, like what are the contents of the phone? What else? I understand and I'm appreciative of the summary that was presented by the detectives, but again, you know, this is just a summary of information that they felt was relevant to the case at hand. So that's the information that we have to go off of, which was why I was requesting whatever additional information they have so that we can have our tech professionals run whatever scans or searches on it. If the court we're in a tough position because my client is in custody. He is, you know, asking that this matter be handled expeditiously. He's asking that we continue on with the hearing, although all of that information has not been presented to us. We are at a bit of a disadvantage. I don't know how much information the people themselves have from the phone. I know that we all only have this that was presented to us by the police.
When you say this,
there was the digital evidence forensic report that was provided to us by the police department.
the time that you met
That is
with
correct.
them? Okay,
Yes.
all right.
Yes, so I know that Ms. Tanha is in receipt of that as well. I do not know if she's had an opportunity to view the entire contents of the phone or if we're all just relying on this. I say that to say that our concern was, again, if there's any additional information on the phone that may be beneficial to us, we don't have the privilege of having that. But I have not been able to receive my client's permission to ask for the adjournment. We are ready to proceed with the information that we have, but that's kind of where we are. Which is why we didn't request the adjournment. My client wants to proceed with the hearing today, but I just wanted to inform the court that the information we have is what has been presented to us by the detectives.
I thought, and I don't have the email in front of me, but I thought there was a request regarding a PR bond. I think you asked, would the people agree to a personal recognizance bond on it and the like? that was a definite no. Very quickly came back. And then I thought you had indicated, and again, I'd have to see it, that you were ready to go forward
With the
with
information.
with the information that you had.
That is correct, yeah.
Now, I will just tell you that I took that to mean that I've looked at what's there and it's sufficient to make sure that I can adequately proceed through this preliminary examination. I'm hearing something a little bit different, and I just want to make sure that what I understood you were communicating to the court was what I just said.
So, Your Honor, Judge, essentially, I think, I mean, all that the defense is saying, or that I am saying, is that I have had an opportunity to review all of the information that has been provided by the people. Knowing that there is additional information out there, I have not reviewed that. Do I feel comfortable proceeding? I don't know what is on that information, but I mean, even based on the information that has been provided to us, I don't expect anything, at least that would be detrimental to my client, but I just can't, I don't know. I cannot say that there's information that would be beneficial to my client that I've, been able to, that I'm comfortable proceeding without. If I can talk to my client a little more, but I spoke with him yesterday prior to sending that email, and his position was that he wanted us to proceed today.
Okay, all right. Yes, go ahead.
If I could just for the record, first of all, the defendant being in custody is not unique. We have defendants in custody all the time. We've had search warrants for defendants' phones all the time. I will say this, and I think this is important for the record and for the benefit of the defendant. I know this court and this defense counsel have done excellent, diligent work in being very patient with making sure that his rights are protected, making sure, as have I, making sure that we do our best to pull any threats that look like it could be potentially exculpatory, potentially beneficial to the defendant. We have turned over anything that it looked like it'd be beneficial to the defendant as soon as we've seen it. I've communicated with counsel, and she's been amazing about communicating with me throughout this process to make sure that his rights are protected. The witnesses, the victim, have been here multiple times. What is unique about this situation is the amount of work and diligence that has gone into making sure his rights are protected in this case. It is very rare to have a victim and witnesses show up this many times with this many adjournments, all truly with the purpose of protecting his rights and making sure that we don't miss anything that's exculpatory or beneficial to the defendant. To answer defense counsel's question, I have not reviewed the full extraction of the phone. It's on a thumb drive sitting at our office. There is no way I would have had time to look at that. So any information that may be on there, I don't have the benefit of, other than what we already have and what defense counsel already has. We can simply not have a situation where every case that is set for preliminary examination, we go through everything possible on the defendant's phone. That is just not a realistic expectation to have. And I know that's what the defendant wants, but we also have to work within the parameters of judicial efficiency and, quite frankly, the rights of the victim to proceed with this in a speedy manner. So at this point, again, the normal procedure, as it's been explained to me, and we could put this on the record at some point if we need to, is if the defendant, and this has been asked a few times, if defendant has a specific date, folder, time, anything we can use to pull whatever he claims to be exculpatory or beneficial to him, we would certainly do so. Some of it we already have pulled, and we'll argue whether it's exculpatory or not. We'll go through all of that today. But to have this expectation that for the defendant to be able to review the entire contents of his phone that he's had without giving us any specifics or any offer of proof that is exculpatory or beneficial to him is just not realistic. So I want to make sure the record's clear about the amount of work that's gone into this case and protecting his rights.
Right, and so that this case is a little bit different than most of the ones that come before me where we're talking about this type of forensic evidence. And that is the way it arose was not because the people said we have this phone and we're kind of giving you what's here. We're not sure necessarily what's here, but we're gonna, as we unfold it, we're gonna get it to you. The way this started was really, maybe this is a bit strong, but at least a representation that there was exculpatory evidence for the defendant on the phone. And that's how this all began to unfold, which I think, at least from the court's perspective, gave me some pause to make sure that we found that, or if it existed, that it at least be uncovered, and why we kind of almost came to a screeching halt, but we did at some point to make sure that that could be gotten over. I'm a bit troubled, and maybe it was said before, but I'm a bit troubled with the fact that there aren't specifics haven't been given by the defendant as to what might have been referred to of this exculpatory evidence. I don't know that, I'm not saying it would have to be something very detailed in specifics, but it sounds like to me, we haven't received anything that even tells us what ballpark we're in so that that can be looked at and gotten to the defendant. So that's a bit troublesome, but I just want to point out for the purposes of the record, this happened in at least what has been a unique way, which is what has led us to have these adjournments and whatever. Ms. Ecker, was there anything else you wanted to say, or because I'm going to do something here, I think.
Well, nothing. Yes, Your Honor, just very briefly. And I just want to kind of echo what the court said. This is unique, primarily because this was not something that the people had, or this isn't discovery that the people had from the onset of the case. So when we set this matter for preliminary examination, I don't even think at that point, I'd have to look at the dates, but I don't think that the people even had his phone at that time. If the court can recall, the people could go. So exculpatory evidence, it was my client having a conversation with his father stating that there is some information that may be helpful to him that was on the phone, which is what prompted the police department to go get a search warrant, which we quite frankly have some issues with, but I do think that that's an issue that we can address at a later time, to get the phone. So we're here now, not because this is just your ordinary discovery process, and typically, you know, whatever is given is given. This is information that the people went and took from my client, and has in fact, I mean, at this point, put us at a disadvantage from being able to utilize the information to the benefit of my client. He initially, what he spoke of on the phone was semi-identified. He tells me that it's not in its entirety. There's a video of some sort on the phone, Your Honor. That's what sparked this entire exculpatory evidence conversation, which is what prompted them to go and retrieve the phone. I was able to get the video, but it's a very short video. My client indicates that that's not the correct video, but I don't know how else to get that information other than the extraction from the phone, but he hasn't been able to provide us with any other information. So I don't know, Your Honor. We are kind of in a tough spot.
Your Honor, may I?
Is it, well, I'm just wondering, is it some other video then? I mean, I guess this is now a little bit confusing. Well, it always has been confusing to me, but whoever wants to.
Sorry, Your Honor, this is the first I hear that this video, they pulled a video. And this is the first I hear that that's not the video. I'm sorry, at this point, defendant's playing games and we're not doing it.
No.
We're just not. I'm sorry, let me just finish because this is important. If there is a video, they were at the hospital for 5 to 7 days at most. If there's a video, it cannot possibly be that hard to give us some specificity about what day it was at the very least that this video was recorded, or a time range or something. The video we have is from the hospital. It is very short. I agree with the defense. It's very short. And maybe defendant initially thought that was enough to get him off of this and he's going to walk out the door with that short little video. We disagree. We can certainly have the hearing and just see where it lands. But to now show up, this is delay tactics, Your Honor. We've been here how many times and this is the first I hear this is not the video?
No, well, Your Honor, let me just clarify. When I spoke with the people yesterday, they asked for specifics before. When I was reviewing the information with my client and I explained to him the nature of the video that was found on the phone, he's indicating to me that it's not that it's in another area. He just says that there was, I don't know if the court can understand when you're taking a video, you press the button, you accidentally cut it off. And
I'm not that old. Go ahead. That's all right, Ms. Eckenroley. I'll just, no.
But somehow or another, I think he's indicating that there was user error and he clicked it short. I did not tell the people this. This is information that I just got from him last night when we had met to review this.
And I'm not blaming defense because I want to be clear. Like this is not, she has been excellent about communicating with me. This is, I am concerned with the games that defendant is playing. The reason, and to now he's claiming he's at a disadvantage because we went and got things from his phone. He told us that he had exculpatory information on his phone. If I don't go get that exculpatory information, I'm in violation of Brady. So he's not at a disadvantage. We have done everything we could to find him this supposed exculpatory information. And now because it's not exculpatory enough for him, he says that's not it, there's more. It's just.
I hear you. And I guess I'm a little bit worried because I don't know that I was told that there was a video. I don't know that that's relevant to at least in part my analysis, but there's a video. They have gotten the video, and now, certainly for me, I guess it would be the first time I would hear it today. But there is then an indication, and the people are indicating the first time they're hearing it today, that's not the video. Now, I don't know if that means there was user error and the video got cut short, or that there's some other video he's claiming. That is a little bit unclear to me.
And Judge, I just want to say for the record, my client never asked the people or the police to get his phone and assist him with getting exculpatory evidence off his phone.
Well, but here's the problem. When there's an indication, though, that's made that there's something exculpatory and it happens to be in the possession or can be retrieved by the people, they're under an obligation. So it's not, I understand he may not be asking, but there are certain legal obligations that they have to fulfill. Because certainly the other argument would be made that, yes, there was this there, the people knew it, they didn't do anything. You don't want to hear that either. So here's what, and we could probably go on all day about this. I'm going to give you, Ms. Eckenroley, as I hear from you, you wanted to talk a little bit more with your client, correct? Yes. Okay, so we're going to do that. I believe that is the social worker.
Yes.
Only because I've seen her like 50 billion times here. All right. It's amazing. I'm a pretty bright guy. All right. I am going to, irrespective of where we end up with everything, I am going to take her testimony today. If for whatever reason, if it ends up this way, something comes across where she needs to be brought back, we'll figure it out. But she is not going to, I think this is your 4th time at least down here. 5? Ow. Notice how she said, it was funny, I said 4. She immediately put her whole hand up to let me know that it's 5. Okay, I'm sorry, I discounted. So I'm going to make sure that her testimony is taken today. And then if for whatever reason, something else comes up afterwards, she needs to come back down to clarify some things or some other things need to be explored, we'll deal with it. But I'm going to get her testimony out of the way. You have what other witnesses do you have?
Your Honor, the victim is here. And her son's with her because that's what we had to do.
So,
And Sergeant Matthews is here, Officer Morton's here. So we have all our witnesses that we would need.
okay, but we have 2 outside of the victim. The social worker here is the only civilian
Correct.
witness. Okay. So what I'm going to do is we'll take Mr. Burns back, give him an opportunity to speak with counsel. When we come back, my expectation given is that we will then be taking your testimony to get that out of the way. Okay?
And just so everybody's aware, I believe Sergeant Matthews is going to be gone. So scheduling wise, we'll have to discuss that. He's going to be gone for a bit. I'm going to be gone for 2 weeks, starting next week. So.
And I'm gone. No, I'm not.
The entirety of the extraction from his phone. He is asking that we proceed with the preliminary examination, knowing that that information is not available to us right now. If I could voir dire him, maybe the court would be satisfied with that as well.
Okay.
Okay.
Go ahead. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give before this court will be the truth, whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, go ahead.
Thank you, Your Honor. Mr. Burns, you and I have spoken on a number of occasions about the contents of your phone that was taken by the police. Is that correct?
Yes.
And you understand that they had done a dump of the information from your phone or an extraction of the information from your phone. Is that correct?
Yes.
You understand that we have what is considered as a preliminary or summary report that was provided to us, specifically entitled a digital evidence forensic report that was provided to us by the police. Is that correct?
Yes.
All right, and you know that this digital evidence forensic report does not reflect the entire content of your phone as it is currently. Is that correct? And you understand that because of that, I haven't had an opportunity to review the entire contents of your phone.
Yes.
Okay, and you feel that you are prepared or you feel comfortable proceeding with the preliminary examination today, although we have not had an opportunity to review the entirety of the phone?
Yes, I do.
Okay. And you understand that I would prefer that we do that, but you want to continue with your preliminary examination today, is that right?
Yes.
All right, very good. That's satisfactory for the court. Okay. That being his choice, you may call your next witness.
Excuse me, Your Honor. People call Leah Hollier to explain.
Ma'am, please come forward and be sworn.
Take a seat, Your Honor. Do you solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God? State your first and last name for the record, please.
Leah Hollier, Leahhollier.
You may inquire.
Thank you, Your Honor. Ms. Hollier, could you please tell the court where you work? Okay, and what is your position there? Were you working in that capacity on May 10th of 2025? Could you please share with us a little bit about what your duties include as a social worker at the Michigan Medicine Hospital?
I provide resources, support, education, any needs after hours that patients and families need.
And did you have the same or similar duties on May 10th of 2025?
Yes,
On that date, were you asked to talk to Madison Burns?
Objection, Your Honor. She wants her to testify to hearsay. She asked her if she was asked to do something.
It's a question, not a statement. She can answer yes or no. That wouldn't be hearsay.
I'll agree with that. I'll overrule the objection.
Thank you.
yes,
And were you able to make contact with Ms. Burns and speak to her? Could you tell the court a little bit about how that came about?
I got Paige, the nurse was worried about.
Your Honor, it's not for the truth of the matter at this point. It's for the effect it had on the,
As to her state of mind,
yes.
for
thank you.
why she does what she does. So I'll overrule the objection. I'll allow it. Go ahead, ma'am.
So I got Paige, when I spoke with the nurse, she said that, the patient's mom looked,
Your Honor, I want to object again. I don't think that she would be able to testify to what the nurse said the patient's mom looked like. I mean, it's speculation on whatever it is the nurse may have felt was going on. I think if that's the case, we should have brought in.
Let's do this way. Ma'am, someone told you about the patient, which is the child, their mother, correct? And is that a yes?
yes,
Okay. And because of that conversation that you had, you then did something, correct? All right. I think that gets us through that.
Yes, thank you,
All
Your
right,
Honor.
go ahead.
Thank you. What did you do based on the conversation you had with the nurse?
I met with Madison in a consult room.
And when you saw Madison, what was her demeanor?
She was like visibly shaking and like, she appeared to be, and her shoulders were forward and she was, looks like meager, I guess. She, sad,
Look, I'm sorry, what was that last one?
sad.
Got it.
And what was your understanding? I'm not asking about what anyone said at this point, but what was your understanding of why you were meeting with her?
So the nurse told me she was worried about the patient's mom.
Okay. And you said you met with her in the consult room?
Yes.
How did you first approach Madison? Where was she? Where were you as you approached her?
She was sitting at the table in the consult room. I knocked on the door and I walked in.
Okay, so you didn't bring her there. Your contact started in the consult room with her. Okay, thank you. Based on, again, not going into what anyone said, but based on the conversation, the information you had received from the nurse, did you take steps to make sure that Madison was alone with you? And
Yes.
before coming to the consult room, well, let me ask this. Madison's son, the patient, Benjamin Burns, is that correct? Okay. He was being treated at the hospital at the time?
Yes.
Okay. And what was the setup for his treatment? Did he have his own room? Was he somewhere else in the hospital?
Yes, he was admitted to the 11th floor in a private room.
And who had access to that private room?
Anybody.
Okay. In addition, I should have asked that better. I'm sorry. In addition to the medical staff, who else was there?
So before I met with Madison, before I came to the floor, I looked into the chart to see if it was bedside. That's like standard protocol. And so I read that both parents were bedside.
And is a standard protocol, yes, that's the right way, with the information you received from the nurse, is a standard protocol to, actually, let me rephrase that. With the information you received from the nurse, what is the standard protocol you would follow based on that information?
So for the reason for the referral, then I need to figure out what's going on with the patient, why they're admitted to the hospital, and read in the chart for any other past social work notes to see what I need to know before I go.
Okay. You said you had a conversation with the nurse and received some information that led you to speak to Madison, the mother of the patient. What was the nature of the concern from the nurse?
All the nurse said that Madison looked like.
Your Honor, I think this has been asked and answered already.
I'll sustain that objection.
Yeah, so the nurse said that she was.
Hold on,
Oh,
hold on.
sorry. That means to stop for a minute. I'm gonna, sorry. So, when you receive information of the nature that this call was from the nurse regarding Madison, the mother of the patient, what is standard protocol to follow after you receive that type of information?
To look into the chart to read any past social work notes to gather the information I need to be able to meet with the patient.
Okay, and were there any past social work notes? Okay. What is the procedure after reading the notes?
To assess the situation and provide support and meet the needs of the patient's and families.
Okay. Without going into what the nurse specifically told you, what was it that you were trying to assess at that point? What's in your mind? What is your job to do at that point?
Assess Madison's coping and safety.
Okay. And where did that concern come from?
The social work notes. Sure.
Okay. She appeared sad. She was kind of hunched over. And I believe you said she was, and correct me if I'm wrong, that she was shaking.
Yeah, she was like shaking and like picking at her fingers and just like really like into herself and just like kind of like, I don't know, it's like really first.
Did she volunteer anything to you about why she was upset?
Madison told me
Objection, Your Honor.
Your Honor, at this point, this is excited utterance. She's testified that the victim was shaking. She was visibly upset, and we're getting into why she was upset.
Your Honor, this is not an excited utterance specifically because that wasn't her reason for going there. There wasn't an incident or anything that had happened. She just said that she was sent there to check on her. This can't be excited utterance. There hasn't been enough foundation laid to say the time frame from when.
Why wouldn't it be a present sense impression of what Madison may be thinking at that moment?
She wants to tell what Madison told her is what the testimony she wants to, is what the testimony. That's the testimony she wants to provide to us today.
What I'm going to do is I'm going to allow it and then I'll make a determination as to whether or not I'll take it into consideration. Go ahead.
Thank you. You can proceed.
Madison told me that her and her son were staying at a domestic violence shelter, and but the CPS worker had met with both the parents when the Benjamin got admitted to the hospital, and both parents were allowed to stay at bedside, but she didn't feel comfortable with Dad being at bedside anymore because he wouldn't let her have conversations by herself, and she was trying to talk to the advocate. And the dad wouldn't let her talk to the advocate alone. They wouldn't let her leave the room.
Yeah, I just want to object again to hearsay. This is a whole narrative of what is being told. I still have not seen the present sense impression or the excited utterance behind the testimony that's being given.
And Your Honor, I believe we may be getting there, but if I may lead a little bit, I can
Go
really
ahead.
narrow it down.
I'll allow a little bit more later.
Thank you. Did Madison tell you or make any statements to you about anything that someone had done to her body physically or otherwise while she was at the hospital?
Yes.
Okay. Can you please tell the court about that?
She told me that Friday that she had sex with her with the father of the patient.
Okay. And did she make any statements about how she felt about that.
She didn't want to have sex with him.
And did she make any other statements about what her feelings or her mindset was about what had happened?
She said that it's happened in the past.
Your Honor, just one more time. I will be remiss if I do not make the objection. We still have not gotten to the excited utterance. She's testifying about something that happened Friday. The date in question that she had this conversation with Madison was on Saturday on 5/10. So this isn't about something that had just happened that Madison was still clearly upset about, and it wasn't a present sense impression. Madison was not explaining anything to her as it
Well, but wasn't she explaining something?
as it was actively happening. That's my understanding of the difference.
Well, while they're under the, okay, I see what you're, well, one might argue that, but your objection is to the hearsay of what Madison said.
That's correct.
Why wouldn't this be permitted? Because in essence, she's obtaining medical care or making statements for the purpose of her own medical care or psychological care.
Your Honor, I don't think that, I mean, at least the testimony that's been provided today, she did indicate that she went in and introduced herself, but I don't, there hasn't been any information that was given to us to lead us to believe that either Madison sought out this medical care or that she was.
Oh, does she have to seek it out, or can it, as it seems to me right now, it was basically a referral to the social worker from other medical staff, for which she then goes into some psychological treatment. Why wouldn't that fall into this exception?
I'd like to know a little bit more about social workers training and see if she's even equipped to handle any type of psychological issues or what purpose she was serving in her conversation with her. I think she said initially she is just there to, I don't think I wrote down her exact words, but essentially to check on the needs of the patient.
And the well-being of the patient. Yes, but I guess what I'm saying is the issue is really with hearsay is the reliability of what somebody's saying. And so if Madison is giving these statements for the purposes of obtaining care, why wouldn't that fall under the exception to the hearsay?
We just maintain our objection. I don't think that there's been any evidence or
Objection
testimony.
noted, I will allow the testimony under that theory, as well as I think that present sense impression may apply, even though it may be some time period, she may still be under the exposure or senses of what had just transpired and is relating that. So go ahead.
You can go on if you remember where you were. No. Okay, no problem. We did a lot of talking. So did Madison share with you how she felt about the sexual contact she had with the father of her children? You already testified that she didn't want to do it. What else did she share with you about that?
She said in the past, it's happened before, and she knows that there'll be repercussions if she doesn't allow it to happen. And then she also said, after it happened, he made some comment like, are you mad at me for making you do that?
Did she mention what repercussions? What happened? Was Mr. Burns, and I'm sorry, who she was talking about, did you mention him by name? Or did she just say child's father?
I mean, when I'm talking with patients, the person that is dad.
Okay. And who do you know who dad is, who Benjamin Burns' dad is? Okay. And was he still there at the hospital?
From what I know, but I've never met him.
Okay. After speaking to Madison, what did you do next, if anything?
So I assessed the safety, and I worked with the medical team, and we contacted security, who contacted the police.
So when you say you assess the safety, how do you normally do that?
To assess safety is just if she felt safe with having dad at bedside. According to the chart, because CCS was involved, dad was allowed to be at bedside if he was acting appropriately. And so that's like what I was there to assess, if that was acting appropriately.
Okay, and what was your conclusion? Excuse me.
Because he was making, what Madison told me is that he was making her sleep with him in the bed, and he was making her wear her wedding rings and he wouldn't let her make phone calls without him being present, and he wouldn't let her leave the room without him.
At any point, sorry, one moment, Your Honor. Were you or security able to keep Madison separate from Mr. Burns after that? Okay. At some point, did you, at some point, did she leave the consult room to go back to the room where Benjamin was?
After Mr. Burns had left.
Okay. And was she able to eventually retrieve her items that she had in the room?
So she was very concerned about getting her items from the room. So she asked me numerous times about getting her purse and her phone and her items in her bags. And she was like giving the descriptions of them. And so we asked her nurse, like her nurse would come back and forth into the room. And so she asked her nurse to get the things and she could not find her phone. She left back like a lunch box and her backpack and all these different things. We could never find her phone. Or the nurse could never locate her phone.
Well, Your Honor. And just to clarify, I believe you already said this, but did you ever see Mr. Burns? Thank you. Nothing further at this point. Your Honor.
Before we begin, I just want to be clear. She was concerned about, she's in a different room. She's concerned about the items that she's left in her son's room.
Yes.
Correct. And that, and correct me if I'm wrong, that the nurse or hospital staff went and retrieved her items and that,
yeah.
and that everything was retrieved, but except for her phone. Or
Yeah, well, so the nurse retrieved everything that Madison asked for her to get.
okay, but one of the things that she was asking her to get was her phone. And is it your understanding that was the only thing that Madison asked for that that they were not able to retrieve?
Yeah, and I think from what I remember is that the nurse asked the dad for the phone and he said he didn't have it.
Got it. Okay. Cross-examination.
Hi, Ms. Hollier, how are you? My name is Tanaza. I'm with the Public Defender's Office representing Mr. Burns. I have a few questions for you, okay? All right, so you know what time this was that you said you met with Madison on May the 10th. You know what day of the week that was? That was Saturday. Do you know what time?
Well, my shift starts at 4, so it was like shortly after my day, like 5 or 6.
Okay. And you said when you went into you said you called it a conference room? The consult
It
room.
could be conference room.
Sure. Madison was in there by herself. Okay. And you stated that was on and when you went in there, no one was around the room, no one was in the room. Is that correct? Other than Madison, obviously. You indicated that this was on the 11th floor.
I'm pretty sure. Let me see.
Can I ask what you're looking at?
This is the face sheet for the patient, but it's not from the admission. This is just that. So
Will that refresh your recollection as to what floor you were?
I'm pretty sure it was 11.
Okay. All right. Do you remember speaking with the police on that date? Okay. And do you remember telling the police that you had to separate Madison and Jerome? Do you remember telling them that? Okay. I have a police report that was drafted by the University of Michigan Police Department. If I can show you the section where your interview took place, will it help refresh your recollection on the contents of your conversation with the police? Yeah. Thank you.
Yes, you may approach. Go ahead. No, it's okay. It's all right. No, no, go ahead. Yes. Go.
Yeah, I apologize, Judge. Thank you. I'm sorry. This is session time. Okay. You said that this in the report must have been a misunderstanding? Okay, what is the misunderstanding?
I've never met.
You've never met my client, is that correct? Okay. And you'd never met Madison before, right? Okay, so the posture and the demeanor that she exhibited on that day, you don't know if that's just her baseline demeanor, right? Okay. And you stated that she reported to you that she had had sex with my client on the day before, being that Friday. Okay. But then you also indicated something about the report, the chart, that since there's CPS involvement, that the chart indicates that my client is allowed to be in the room as long as he behaved appropriately.
The CPS worker, that was the safety plans, yes.
That was the safety plan that was provided to. Okay. And you didn't give a copy of that safety plan to the police when you met with them?
That's not protocol.
But you didn't talk to the police. You didn't inform them that there's a safety plan in place or anything else of that nature. Is that right?
I told them that there was CPS involvement.
Do you remember telling the police that my client was extremely upset because Madison had left the room?
Yes, I do, because that's what the nurses were reporting.
But you didn't see my client? Okay, you didn't have any interaction with him at all? And Your Honor, I don't think I have any more questions for this witness.
All right, thank you. Any redirect?
A brief follow-up, Your Honor. Ms. Hollier, you were asked about knowing the victim prior to this incident. You indicated you did not know her. But you also testified specifically to what you saw and your impression of her demeanor. Could you tell the court a little bit about your training and experience and how that helps you in doing your job and doing these assessments?
Well, I'm a clinical licensed social worker, so I've been doing this job since 2016. So I very often assess the safety of patients in the hospital. I have a lot of experience doing it. So when someone's distressed or upset in the hospital, I provide support and assess for safety. I work with CPS and families regularly. So part of my job and normal protocol.
Thank you. And you were asked about the CPS report and the safety plan that allowed Mr. Burns to be bedside as long as he behaved appropriately. What was that CPS report regarding? What was the background of that?
Well, because
Your Honor, I want to object to this line of questioning primarily because this is going to require Ms. Hollier to get into details about cases other than, well, specifically the out-of-county cases that we talked about at our first preliminary examination on our first date.
Why do you say that?
The safety plan that she's speaking of, the CPS case, those are going to all stem from something that does not have anything to do with Washtenaw County.
But hold on. So what are you objecting to? I guess if she relates that to the court, what is your objection?
Your Honor, I would say that, I mean, I'm going to object based on relevance. I don't think that the details of the CPS plan would be relevant to this case at hand and what actually happened in the hospital room.
Well, I think, first of all, Ms. Hollier brought up that there's a safety plan in the charting and that she had been looking at that. I'm a little bit curious about your objection because then you specifically attempted to begin questioning Ms. Hollier on whether or not the safety plan, she had communicated that to the police. So the fact that you question on that, I'm going to allow the people to question on the nature of that safety plan. So I'll overrule your objection. Go ahead.
Thank you, Your Honor. And again, the question was about the safety plan. If you could relay that to the court, please.
Sure. We're talking about the CPS report and the background and the safety plan that you mentioned. What was the safety plan? Where did it come from? What was it? What did it contain?
Well, in the chart, the social worker wrote that there was a history of domestic violence and CPS was involved due to the child witnessing domestic violence. That the child and the mom were staying at a shelter and did not know where they were currently staying. But due to the patient being admitted to the hospital, that CPS was allowing dad to stay at bedside. You know, so that's an exception, right? Normally, during a shelter, dad's not with them, but because the child was admitted, that's the exception. And so, and the exception is that as long as he behaves and was acted appropriately at bedside. So this safety plan is that he has stayed appropriately.
Okay. Thank you. Nothing further.
Anything else?
No further questions.
Okay. Ma'am, thank you. Thank you for your patience. We appreciate it.
And may she be excused, Your Honor?
Any objection?
I don't have any objections, Your Honor.
This witness is excused.
Next, Your Honor, people call Officer Morton.
Sir, please come forward, be sworn.
See, raise your right hand. You solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God. Say, so your first and last name to the record.
My name is Officer Aaron Morton, Aaron, ERRON, last name Morton, MORTON.
You may inquire.
Thank you, Your Honor. Officer Morgan, could you please tell the court where you work?
I work at the University of Michigan as a police officer.
Thank you. And were you working in that capacity on May 10th of 2025?
Yes,
And specifically, were you working on duty that day?
I work, yes.
Thank you. And if you could tell the court just briefly what your duties include in that capacity.
In that capacity, my duties include traffic enforcement and also attending to dispatch calls for criminal investigation.
Okay. And does that involve Michigan Medicine, the hospital?
Yes.
Does that involve Mott Children's Hospital?
Yes.
Okay. And on that date, were you called out to Mott's Children's Hospital in the evening around 7 o'clock p.m.?
Yes.
And what was the nature of that dispatch?
Initially, I was dispatched to a trouble with subject call at Mott, 12th Ward of Mott. Upon arriving at Mott, quickly learned from people on scene that there was more to the call than just trouble with the subject.
And as you received the call, were you informed of who the subject was that there was trouble with?
Yes, after I got down on scene, I was, briefed by the hospitals that were there. They advised me on, was there and the so.
And did they advise you as to who the subject was that they had called about?
Yes,
And who was that person?
it was Burns. It was Burns.
Thank you. Did they indicate to you what the trouble was?
Yes, they did indicate what the trouble was. As I spoke with hospital security and also the health worker who was there, I learned that it was a little bit more than just general trouble with someone at the hospital being upset about something.
Did you at some point make contact with Mr. Burns? Visually saw him, in-person contact? Okay. Do you see him in the courtroom today? Could you please point him out and describe an item of clothing he's wearing?
I'm sitting right there, front seat, wearing a orange jumpsuit.
Thank you. Your Honor, may the record reflect that the officer pointed to defense table and identified the defendant.
That objection record shall so reflect.
Thank you. So you said you initially spoke to, well, let me ask this, who was the first person you spoke to when you arrived at the scene?
So the first person I spoke to that had all the details of what was going on was the social worker.
And who did you speak to after that?
After speaking with the social worker, I spoke with Madison Burns.
Do you remember what Mrs. Burns' demeanor was when you spoke with her?
Can you say that one more time?
Sure. What was Madison's demeanor when you spoke with her?
She seemed really timid, really like, kind of in distress, like really, just really kind of scared about, what was going on.
After speaking to Madison, what did you do next, if anything?
After speaking with Madison, myself and other officers made contact with Mr. Burns.
When you made contact with Mr. Burns, where was he?
He was in top floor, I can't remember exactly what number, but I believe it might have been 6, but he was in one of the rooms at my children's hospital. Patient rooms.
And did Mr. Burns agree to speak with you?
Yes.
And did you then continue to speak with him about what you were called out for?
Well, we moved to another room that was more private.
Okay.
And then more private areas.
Okay. Did you read him his Miranda rights?
Yes, ma'am.
Did Mr. Burns make any statements to you, if you remember, about Madison Burns's demeanor or personality?
He did make full statements, trying to refresh my recollection, but I believe he was made comments about her begging regarding the situation of having sexual intercourse, and then also too, there was another part of our discussion where he made a comment regarding her being easily coerced. That he's been with her for approximately 7 years. So.
Thank you. Sorry, Your Honor, if I may have a moment. After speaking to Mr. Burns, what did you do, if anything?
After speaking with Mr. Burns, we placed him under arrest.
I do nothing further right now. All right.
Cross-examination.
Yes, Your Honor.
Officer Morton? Officer, right? Okay, good afternoon. My name's Chinaza. I've got a few questions for you. I'm the defense attorney representing Mr. Burns, okay? You indicated that you read my client his Miranda rights. At what point did you read him the Miranda rights?
After we moved from the patient room to the private room.
But did you talk to him at all in the patient room before then?
Yes, we did.
Okay. And what information did he give you in the patient room?
Patient room, we were trying to let him know that we were there to talk to him about the situation going on there in the hospital. And then we advised him that we could move to a more private room. And our concern was the child that was in case anything went sideways, we want to not be around the child.
Okay.
We moved to a private room.
So you're saying that he didn't say anything to you before you all moved to the private room?
I can't recall if he said anything on the page,
Okay,
but he read him Miranda rights once we got to the private room.
okay. And you said when you spoke with Madison, she seemed distressed. Excuse me. She seemed distressed and scared. Obviously, you had never met Miss Burns prior to then, right?
No, I did not.
Okay. So you don't know what her demeanor is on a normal basis?
No.
Okay. And you stated that this happened on the 12th floor. Is that correct?
That's what I recall.
Okay. All right. And when you talked with my client, did you Did he tell you anything at all about the date? Well, I'm sorry. Did he tell you anything at all about his Miss Burns, Madison, that is, having relationships with other men?
He did.
I'm gonna object, Your Honor. It's hearsay at this point.
It's my client's statements, Your Honor, and I think that it goes to specifically,
That's why it's going to be hearsay if you're offering it.
not necessarily, well, well, Your Honor, Officer Morton previously testified to my client, telling him that you testified that he said that she's easily coerced. Is that what you? I apologize, Your Honor. Okay.
I'm saying objection, you can go ahead.
Thank you, Your Honor. What was my client's demeanor when you spoke with him?
And he seemed very surprised.
Okay. Was he cooperative with you?
Yes.
And he denied the allegations, right? When you spoke with him?
Regarding, yes, he denied that,
You wanna object him again if we're gonna get into specifics? I understand you can answer yes or no, but I limit it now.
yes, he denied that allegation.
Okay.
Thank you.
And when you spoke with Ms. Burns, is it true that, well, okay, so let me do this. You drafted a report after your interviews and investigation with the individuals involved in this case, right? And your report is a reflection of the information that was provided to you. Is that correct?
Yeah.
It's also a reflection of the information that you relied on to make a decision to arrest or not arrest. Is that correct? Okay. And when you spoke with Ms. Burns, you were provided with information as to the reason that she decided to agree to the act. Do you recall that?
That agreed to the act.
Having sex with my client.
I'm gonna object, Your Honor. This is hearsay.
Response?
Your Honor, I'm actually using it for more so, this is partly the reason that Officer Morton decided at that time to bring the charges against my client or to arrest him. This wasn't just a simple, my husband and I had sex. It was information that was given to him by the complaining witness in this matter that led him to believe that a crime had been committed.
Are you asking about her statements or his statements about her statements?
No, her statements directly to the officer.
I understand that it may, given the testimony that has come in, I'm going to allow it in this instance. So go ahead.
Thank you, Your Honor. Madison admitted that she did have sex with my client. Is that correct?
That's right.
And she said she did it out of fear. Is that correct? Okay. Fear of him hurting her or their son. Is that correct?
That's right.
And that was information that you relied on.
That's right.
But she didn't tell you that he forced her to do anything, correct?
She basically stated that he had been touching her unwillingly, and she didn't want to touch me.
Okay.
Since he's been there, and then over time, being there constantly, the touching continued and the asking to have sex continued. It, she advised that she did not want to have sex with him, told him that he did not want to have sex with them. And then it got to a point where she gave in out of fear of being harmed or her child being harmed.
Okay. No further questions, Your Honor.
Any redirect?
No, Your Honor.
Officer Morton, thank you very much, sir.
And also be excused, Your Honor.
Any objection?
No, Your Honor.
All right, the officer is excused. Any additional witnesses for the people?
And we would have two more witnesses.
Two more?
Yeah.
Who might those be?
Sergeant Matthews. And the victim. Based on some of Sergeant.
All right. Let me call your next witness. Check.
People call Sergeant Mike Matthews.
Be bringing, come forward and be sworn. Are they bringing, yeah. Okay, so they've got to go down and get them. Right. Okay, all right, go ahead, sir.
Right, you solemnly swear in front of the testimony you're about to give to be the truth and all truth and nothing but the truth, so help you God.
I did.
See, please go ahead, first and last name for the record, please.
Michael Matthews, Michael, last name is Matthews.
You may inquire.
Thank you, Your Honor. Sergeant Matthews, could you please tell the court where you work
I work for the University of Michigan Police Department.
and what is your position there?
My current position is a detective sergeant, supervising special victims.
And what are some of the duties and responsibilities you have in that position?
Investigate cases that come in that are of an interpersonal violence nature, and also supervise 1 to 2 officers with their casework.
Were you working in the same capacity in May of 2025?
I was.
And was your attention at some point directed to a case involving a Jerome Burns?
It was, yes.
Could you please tell the court how that came about?
Sure. So during our Monday morning briefing with other department members with the Criminal Investigations Unit, I was informed of custody interpersonal violence that had taken place over the weekend, with that case being walked through by the on-duty detective, and then obtained the casework that he had started and began to manage that case.
And when you began managing that case, what were the steps you took?
It would have been to review everything for completeness. It would have been to listen to any potential jail calls that were made by the person that's taken into custody, and it would have been to attend any court hearings that were scheduled, and reach out to the survivor.
Thank you. And were you able to reach out to the survivor, the victim in this case?
It did initially reach out and left her a voicemail. Don't believe that was the case.
And did you review jail calls for this case?
I did, yes.
And did you find anything noteworthy on those jail calls?
There were several jail calls made during the time that the defendant, Mr. Burns, was in custody. The calls were made to family members, his mother and father, and also subject identified, I believe, as Luke Decker or Decker Lucas. And those calls, they were of interest.
Okay. And can you please tell the court why they were of interest, starting with the calls to Mr. Burns's parents?
During one of the calls to Mr. Burns Sr., defendant Burns indicated that there was a recording on his phone, indicating, some sort of evidence that would exonerate him regarding, this allegation of CSC.
Did he make any statements to either of his parents regarding Madison? Sure, regarding Madison and this ongoing case. And
He indicated that he needed her to tell the truth about the case.
the other call was to, I said, the Lucas Decker.
Right.
And what was of interest in that call?
In that call, he had indicated that as soon as he got out of custody, he would obtain a lifetime PPO against Madison and take their child and move, I believe, out of state. I don't know, I have the exact quote written down, but I don't know exactly what it is.
Do you have that written down in your report?
Yeah, it's on the back page of my report.
Would it refresh your recollection to review that? Is it right over here?
Should be, yes. The police report.
Your Honor, if I may approach before I do, I'm showing defense counsel the report authored by, yeah, I think he wrote some notes on the back of it. Wait,
That's
is it on the back of Officer Norton's report?
it.
Okay. Are you referring to the handwriting?
I am, yeah. I do have the audio too available.
One moment, Your Honor. Okay, and what I'm going to approach with is, I believe what's in the report regarding the jail call. Should have a supplement for that. This is a call. And that's written by Sergeant. Yeah. Okay. Turn my approach.
Wait,
Sergeant, what I showed counsel and what, of course, you can basically look at is the supplement that you offered regarding the jail call.
And please let us know when you're done if that refreshes your recollection. Did that refresh your recollection?
Yes.
Okay. And what were the statements made to Louis Decker?
So in addition to obtaining the personal protection order, Mr. Burns also asked Mr. Decker to coordinate with contacting the bank about his vehicle and having members of the bank repossess the car after this court had given permission for Madison to have that vehicle. Specifically, Mr. Burns indicated the location where the vehicle was expected to be. He named La Casa, which is a domestic violence.
Yeah, I'm just gonna object to the nature of this whole narrative that's being offered by the officer, primarily because it's not relevant to the case at hand. I know that it is things that stemmed out of the case after it had been charged, but I understand it was a part of his investigation, but it gets us no closer to meeting the standards that we're here for today.
Your Honor, this is all behavior that was designed to make it difficult for this victim. First of all, it shows the pattern of power and control and coercion that's underlying this whole case. But it also demonstrates the length that this defendant was willing to go to make it as difficult as possible for this victim to come to court and to testify. I'm going to be asking more questions about what happened here in court that led to this court's order for that vehicle to be turned over. So we'll get to all of that, and I can ask those questions now if that helps defense counsel see the relevance. But certainly bond violation, violations of bonds, violations of court orders, making it more difficult for victims or witnesses to appear are all very relevant.
Overrule the objection, I'll allow.
Thank you. Please proceed.
So during that phone call to Mr. Decker, Mr. Burns indicated the location that the vehicle would be at. He's provided Mr. Decker with the name of his bank, which was Door Financial, in addition to two people that worked at the bank that he has dealt with before. He indicated that, or was asking Mr. Decker to contact those people, let them know that the vehicle was there after the court had ordered the vehicle to be turned over to Madison, and have the bank come and get that vehicle as Madison was unloading her property at the domestic violence shelter.
Thank you. At some point, did you, based on this court's order or permission, accompany Madison to retrieve some of her property from what had been the residence of Madison and Jerome?
I did, yes.
And when you did that, was defendant's father present?
He was, yes.
Was there anything of concern to you regarding that interaction? Was he there while you were retrieving the items?
He was, yes.
Was there anything of concern to you that happened during the standby?
Initially, during the civil standby, we were accompanied by a Livingston County deputy. That deputy arrived and left shortly thereafter. He inquired as to whether or not it was court order to allow the standby. Once he left, the initial tone was cordial. And I should note this is a second story apartment with a walk up with a set of steps. With the truck, Mr. Burns' truck had already been parked outside of the residence, and some of the stuff needed for their son had been loaded up into the back of the truck. As Madison was gathering different belongings and piling them at the entryway, I began to assist and move the property downstairs. When I returned, I found that the father, Mr. Madison, Burns Senior, was engaging with Madison about her.
I want to object, Your Honor. This is going to be hearsay. This isn't even a party that's related to the case at all.
Fair enough, Your Honor. I'll ask it differently. Without going into without going into what was said, did it give you concerns about? I'll come back to that actually, but we'll come back to it. I want to make sure we're going the right way. Moving on to this case proceeding, were you here in this court ready to testify for this exam at a previous date?
Yes.
And at that point, did you learn that there may be information on Mr. Burns's phone that might be relevant to this case?
Yes.
Could you tell the court a little bit about the phone? Where was the phone initially as this case started?
So originally the phone went with Mr. Burns to Washington County Jail, was logged into his property. Early on, and listening to some of the phone calls, there was mention that there was a recording that was obtained. I looked at the property sheet that the officer filled out when they lodged Mr. Burns at the jail, and looking at that property sheet, the phone was the only item listed that could, be able to make a recording. So in an effort to preserve that, I wrote a search warrant, which was approved by the Washington County Prosecutor's Office, sworn to by Magistrate Garwick, to seize the phone, which I did, and I logged it into our evidence room.
And did you at some point, were you tasked with conducting or getting help conducting an extraction of that phone?
Subsequent to the phone being logged into evidence, I wrote a second search warrant for a forensic download of that phone. And once that search warrant was obtained, following the same process that I outlined previously, I turned the phone over to Detective Cargill, who did a forensic download.
And was that evidence shared with you
It was.
from Detective Cargill? And did you then share that evidence with the prosecutor's office with the intent of it being shared with the public defender's office?
Yeah.
In fact, did you make 2 copies of the thumb draft, the preliminary report, and make that available to both offices?
I did.
Was there any evidence associated with this case or potentially associated with this case on defendant's phone?
There was.
Was it your understanding as you're going through this process of obtaining the evidence that there might be potentially exculpatory, potentially beneficial information to the client based on his representation or his counsel's representation?
Yes.
I'm going to ask you about some pieces of evidence specifically. Before I do, actually, I'm sorry. If you know, does the victim in this case have more than one phone?
My knowledge is.
And are there separate numbers associated with those 2 phones?
Yes.
Your Honor, if I may approach with People's Proposed Exhibit number 1, I'm showing it to defense counsel, but it has been shared in discovery as well.
So, Your Honor, I know she has not yet been able to lay foundation, but I am going to object primarily to the introduction of anything that was a proof of the search warrant itself. I know that the detective has testified to the steps that he used or went through to obtain the search warrant. But I believe that we have not heard testimony yet as to what the search warrant would then subsequently allow him to do. I have a search warrant. I have objections to that. So just for the
You
record,
have objections to what?
to allowing.
First of all, we're talking about the second search.
That's correct, Your Honor. Second search warrant. So I guess I would ask that people just lay a little bit more foundation in regards to at least how we got to this. I understand that it was from the search warrant, but I mean, if we're ready to proceed, I do object to this particular exhibit coming in primarily because the search warrant essentially that was given did not give any.
Excuse me a second.
Sorry, Judge.
Because I mean, I was following you up until that point, kind of.
Yep.
I don't know what's being attempted to be admitted. So it's a little bit hard for me to place what you're objecting to in context. is there a way to sort of generally describe what the purported exhibit 1 is?
Do you like me to? Okay. Your Honor, this is a text message, part of a text message string obtained from the defendant's phone.
Got it. Okay, and you're objecting on the grounds that,
The search warrant itself that allowed the police to extract this information from my phone it's extremely broad, Your Honor. There were no limitations based on what the magistrate had signed off on giving them permission to search. I was hoping that people would be able to get to that and allow the officer to testify to what he was actually able to extract from the phone, or at least what permission the search warrant allowed him or they offered to him.
Your Honor, I don't have a problem asking more questions. What I'm now concerned with is that there is an objection to the search warrant. There's a claim that the search warrant is not good, essentially, which should have been a motion before this court prior to today. I'm at this stage not prepared in the middle of testimony to argue the validity of the search warrant. So that's not what I'm going to do. I don't have a problem asking more questions. If counsel wants to voir dire on the exhibit, of course, that is her right. However, I'm not going to have a whole hearing on the search warrant at this stage.
so what is your objection to the search warrant? I guess
So essentially, Your Honor, my understanding of the search warrant, the second one that is,
Can I, and before you answer that, I mean, just timing wise, as I'm done, recall and understand, your client makes a statement that on his phone is something exculpatory or something that may clear him or beneficial to him.
Yeah.
Based upon that, I think maybe we can all agree on that. Based upon knowledge of that, University of Michigan Police obtain a search warrant to basically go into the phone. Are we all on the same page?
that's correct.
They obtain certain things. It doesn't, I don't know whether inculpatory or exculpatory. But now you're objecting to the warrant itself.
Your Honor, in reviewing the warrant, the warrant gives permission for a full review with no specific date range being requested, or basically being given an order to police. Our issue with that, Your Honor, is the fact that it's overly broad. It gives them full access to the phone. I understand that the people may have wanted this, or the court may want this in motion form. That's something that we absolutely can do. However, just in reviewing the search warrant itself, there just are no parameters to it. It gives them free.
So because of that, you'd be objecting to the admission or even questioning regarding proposed exhibit 1.
That is correct, Your Honor. And I mean, that's correct, yes. And I think that objection would subsequently stand for any other exhibits that pertain to the extraction of the phone. And I just want to bring it to the court's attention in regards to timing. There was just a recent case that was brought to, that I found out about that gave rise to questions, People versus Carson. It gave rise to questions about validity of search warrants and the level of unconstitutionality. This is a case that was just decided on July the 31st. So it's a very new case. I know that again, and just preparing for.
Is that, I haven't seen that case, but I guess, is that something in specific to the narrowness of the search of an electronic device? Is that?
That's what the case speaks about.
Your Honor,
Yes,
sorry, may I?
you may.
Your Honor, other than my initial problem with objecting to the search warrant at this stage, that objection stands. We have a situation where, and we just went over this morning, where the defendant is claiming without any specificity whatsoever that there is exculpatory evidence on his phone. We have asked for specificity multiple times. Had there been specificity in his statement, perhaps the search warrant would have contained some specificity. When we are told that his phone has exculpatory evidence with nothing more to go on, and are essentially tasked with going on a fishing expedition and exploring this entire phone, and in addition to that, he will not give consent, which is his right. He will not give consent, despite many conversations, for us to get that potential exculpatory information. The only thing we can do at that point, so that we are doing our jobs, so that we are protecting his rights, so that we are not violating the law and the Constitution, is to get a search warrant to go into the phone to see if there's exculpatory evidence. We have done our best. Law enforcement has gone above and beyond trying to find this supposed exculpatory information. What I was about to present was a text message that is potentially exculpatory, that has been shared with defense, that the defendant is well aware of because it's in his phone. And now there are problems with the search warrant being too broad. There's been conversations about needing to review the entire contents of the phone, but now there's a problem with the search warrant being for the contents of the phone. Your Honor, I'll leave it to you. I don't know what else to do at this point.
Well, I was just about to say, because I can really, and I understand, I guess, the difficulty of the circumstance, but we spent this morning, well, the latter part of the last hearing, and it seems every time we come here, arguing over something that the defendant claims to exist on this phone. He doesn't consent to the phone. They get a search warrant to find what he says is evidence favorable to him. Now, the danger in that is that when they go and do this, there may be found things that are not favorable to him. If I just make the presumption, and again, I haven't read the text message, but let's say it's something that is not favorable to him, then I not only am getting an objection to that text message, but I'm then getting an objection to the search warrant. And I guess in essence, the whole process which led to the search warrant and the discovery of this proposed Exhibit 1. And so I have to say I'm a bit baffled by that. I'm a little bit concerned that it was a recent case, Carson, and how you're saying that case, but I believe there were a couple of previous cases that basically argued the narrowness of a search warrant regarding an electronic device, that you just don't go carte blanche.
That is correct, Your Honor. From my review of the case, it does speak about the narrowness of the search warrant, especially when it comes to electronic devices, essentially indicating that people's entire lives are on their electronic devices. Obviously, the outcome for Mr. Carson in the case was not, he didn't get the decision that he was looking for. However, and specifically, he was asking for a new trial. He was not given the new trial, but the Supreme Court did have a lot to say about where we stand right now in regards to search warrants. And again, this is a case that It's a hefty case and still
And-
working through it, but.
Your Honor, I am familiar with Carson. Our office actually has taken very, very detailed measures to make sure that our reviews of search warrants are run by our appeals department. We've had trainings. I'm aware of all of that. However, those situations are very different because if we were to go and take defendant's phone looking for evidence that is inculpatory of this crime, then yes, we would absolutely have to narrow it down. We'd have to follow all, and it's not just Carson. I mean, there's a long history of what search warrants are supposed to look like and what they're not supposed to look like. That is not the situation. And in fact, it was actually defense's argument this morning that this situation is unique. So you can't have it both ways, and that's where we are. And I understand this defendant wants everything to be speedy, but he also doesn't want us to be able to use the evidence. When he is insisting on us proceeding today and claims that he is ready to go, the expectation cannot then be that you're all of a sudden out of the blue going to claim that the search warrant is invalid. That's just not how things are done. We cannot start this. We cannot be ready to proceed to then have a problem with the search warrant and tie our hands so we can't use any of the evidence.
Well, and that was one of the things I was going to say that, and maybe Miss you can, because I have not read recently with Carson. I've gotten a synopsis of it, so I mean, I understand the concept, but is there something in that case that would make it applicable to a circumstance such as this, as opposed to a circumstance where the police, through an investigation or otherwise, seize a defendant's phone, looking at it initially for items of evidentiary value to their case?
And Your Honor, I will say that is the difference in our case, right? In Carson, his phone was seized as a part of it was seized, he was subsequently arrested, and that was a part of the evidence or investigation that the police did in that matter.
Right, and would you agree that makes this that's a big distinction between what Carson was getting at in terms of the narrowness of what one is looking for, as opposed to this circumstance that we have in this case? And I'll be honest with you, I'm a little bit baffled because earlier this morning, what we were talking about was that there was a request by the defense for the full download that the police obtained. And we went through that. I took a break so that you could talk to the client about the implications of that and where he wanted to go with the case. And now while I want it, now I'm objecting to the fact that the police haven't did that.
And that's correct.
Keith Johnson's court appearance took an interesting turn as his attorney explained that the case could potentially be resolved without a lengthy trial. According to the proposed offer, Johnson would need to complete an alcohol-related course and write an apology letter. In exchange, the case could be reduced to a misdemeanor with costs only. The judge made sure there was enough time for Johnson to complete everything before setting a tentative plea and sentencing date. But the courtroom later shifted to another defendant, Lee Rogers, who was appearing by video. Before the legal discussion could even begin, the judge had to give him a quick lesson on how to mute and unmute himself. What started as a simple status conference turned into a lighthearted Zoom 101 moment, with Rogers admitting that technology was not exactly his area of expertise. However, the tone soon became more serious when Rogers explained that he had recently completed treatment at Hazelden. Then came the moment that stood out most. Rogers revealed that he had been sober for 60 days, the longest period of sobriety in his life. The judge immediately praised him, calling it a huge accomplishment and encouraging him to keep taking things one